do you think that it would be appropriate for some law being passed, some permission being granted for the judiciary to retain everything it generates for its use?
Indeed, it would be a good idea if that was done, but I'm afraid the revenue that we generate is also backed by law. It must go to the consolidated fund, because it is from the consolidated fund that the government, applies to its activities, including institutions of state and the judiciary. So, to say that the judiciary should retain 100%, I would not agree for that, but I would say that maybe about 50 or 70% must come to the judiciary. Thank you.
Thank you very much. I will then give the floor to Honorable Bede Awantanzuma Azidi.
Thank you very much, Honorable Chairman. Congratulations, my Lord.
Thank you.
Yes, my Lord, I've gone through your CV and I've also listened to you. Honestly, there's absolutely no reason why you should not be appointed a Supreme Court judge.
Thank you.
You have done all that it takes to become a judge, right from the magistrate through the ranks at the Supreme Court. And I think that I will not worry myself about whether you are qualified to be a Supreme Court judge or not. You are. So I have no questions for you, my Lord. As far as I'm concerned, you are fit for the job and you are fit for purpose. Thank you. Congratulations.
Thank you very much. It's now the turn of Honorable Tambuli. You have the floor.
Thank you very much. Hello, good morning and welcome.
Thank you. Good morning.
And congratulations, my Lord. My Lord, I heard you talk about the jurisdiction and the workload of courts in Nigeria, Federal Republic of Nigeria. And I want us to do a bit of comparison with ours here. Okay. So the Nigerian Constitution 1999 as amended, and in their case they call it sections. Section 2302B of the Nigerian Constitution provides, and I quote, "The Supreme Court of Nigeria shall consist of such number of justices of the Supreme Court, not exceeding 21, as may be prescribed by an act of the National Assembly." In Ghana, ours is in Article 1281. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. End quote. So, in other words, they have a ceiling, but we have a floor. So, at some point during the presidency of President Buhari, they even had 13 justices of the Supreme Court of the Federal Republic of Nigeria. But is it sustainable? And having regard to the fact that Article 128 is not an entrenched provision. The entire Chapter 11 has Article 125, 127, 145, and 146 as the only entrenched provisions. Do you think we should do something about this, especially having regard to the fact also that 230 million people reside in Nigeria and about 32 million in Ghana. We have not less than 9. They have not more than 21. Don't you think by reason of these numbers, ours is a bit on the high side and potentially can even go way higher?
Thank you. Thank you, Mr. Chairman. I will start off by saying that if there should be need for expansion or capping of the Supreme Court, I think that there must be a wide and expansive consultation among all the stakeholders, lawyers, GBA, constitutional lawyers, I mean, the academia, even the political parties themselves, so that we will all come to consensus as to what we must do. And if there's a consensus that there should be a cap, then the law has to be amended. Fortunately, as we said, I also looked at the law, and that is not an entrenched provision of the Constitution. So the amendment, as it were, can be done without much difficulty, except that, as I advocated, there must be a very wide consultation. I brought this report, an annual report of the Judicial Service, and as at June 2023, this report was issued to us last week. 595 cases were pending in the Supreme Court. So when we are talking about capping, we must also take into consideration, as I've said already, the number of cases that are in the Supreme Court pending for attention. Thank you.
Thank you, Mr. Chair.
Any follow-up?
Follow-up question.
The ground rules.
In view, I acknowledge, the ground rules. In view of the expansive jurisdiction of the Supreme Court, chieftaincy, jurisdiction, election, Supreme Court, presidential elections, and so on and so forth. Now, don't you think that there is need for us to stop the jurisdiction somewhere of the jurisdiction of the Supreme Court, especially we can take, for instance, interlocutory appeals. Rules of Court Committee can, by CI come up with something. Can you propose some limitation to the jurisdiction of the Supreme Court? Which jurisdiction do you think should be set aside and at the Court of Appeals? And which one should continue to remain with the Supreme Court? And by the way, at some point, the Supreme Court of Nigeria had over 10,000, pending cases. At some point in 2022, over 10,000 pending cases. I thank you, Mr. Chairman.
Thank you, Mr. Chairman. You see, I will say that first and foremost, the Court of Appeal must be very strong. I mean, being strong means that we need judges who, they are doing their work very well, I must admit. But we must make it stronger than now, so that some of the cases may not travel beyond that. But there must also be conscious effort on the part of the legislature and then the Rules of Court Committee to ensure that, and of course we can't do that without, we have to subject the debate very wide. So we have to see the number of cases that will go to the Supreme Court. Because, permit me to use the UK example. UK, most of the cases end up at the Court of Appeal. The cases that go to the Supreme Court will go there with the leave of the Court of Appeal or the Supreme Court. So you find that they do very little cases, and so the Supreme Court is always, they are not saddled with so many cases. So if that is what we want to replicate in Ghana, then the law itself must be amended so that some of the jurisdictions must be taken away. For example, if I should be given the opportunity to say, to recommend, the prerogative of mercy that is exercised by the president. I think that should remain with the executive. It shouldn't come to the Supreme Court. Because after all, the Supreme Court itself has pronounced that when it comes to matters of advice, the president may take it or may not. Thank you.
My Lord, with the leave of the chairman.
Please, he said the mercy, not REITs.
Prerogative of mercy.
Mercy, yes, prerogative of mercy, which is vested in the president. The president may come to the Supreme Court for advice, and once the interpretation placed on the advice is not compulsory or is not binding on the president, he feels that it should rest with the president. Yes.
So that's one example.
Honorable Bafoewa, you have the floor.
Congratulations, my Lord.
Thank you, Chair.
My Lord, I was happy to hear you say that there's a need to build a strong court of appeal, so that a lot of the cases that travel as far as the Supreme Court will be reduced. My Lord, when you take the law reports of the Republic of Ghana, there's one observation you are likely to make. A significant number of the cases determined by the Supreme Court, by the Court of Appeal, are overturned by the Supreme Court. In recent history, if you even look at the number of judges being appointed from the Court of Appeal to the Supreme Court, it's indicative of how strong our Court of Appeal is presently. But this is the situation. Why are we having that experience? Because currently we say we have a strong Court of Appeal, yet a significant number of cases are being overturned by the Supreme Court.
Thank you, Mr. Chair. In fact, I haven't had the benefit of that research you are talking about. So let me file a caveat. I will not be able to answer directly why that is the case. If I've had benefit of it, maybe I can profess an idea as to why that is the case. Thank you.
Mr. Chairman, no question.
Thank you very much. Honorable Aliklim Akurubu.
Thank you, Mr. Chair. Congratulations, my Lord.
Thank you.
Yes, there has been growing concerns about expanding access by breaking the monopoly of the Ghana School of Law. There are a lot of people who have completed their LLB and are home. Some of us are even planning to go read law, but we get scared about what is happening. What do you make of it, or what can you advise for our students who have been home for many years and haven't been called to the bar? Thank you.
Thank you, Mr. Chair. The number of students that are trying to get to the law school has increased significantly, because now we have universities that are offering LLB courses. In our time, it was only the University of Ghana, and then from there you come to the law school, so the number was few. Now it has been expanded without corresponding maybe infrastructure to take care of all those students. So I believe that is why the numbers have swelled. Now proposing a solution, offering a solution to the problem, I would think that those who have already passed their LLB and are waiting to enter the law school must be given what we call an immunity. Immunity in the sense that they could be grouped and then given maybe depending upon how the General Legal Council are going to do it. I think they can put a system in place where the students can be, grouped and then they are given the chance to do their courses at the law school. Now we have Kumasi Campus Law School. I think UPSA is also doing the same. So if they are given immunity and all of them are offered the opportunity to go to the law school, because invariably everybody who has entered the law faculty to do LLB wants to become a lawyer in the long run. And I do not think it would be fair for us to impede the progress of the students who want to come to the law school. So the system must be looked at again holistically. The General Legal Council, together with maybe the director of the School of Law, they need to sit down and fashion up. And of course, there must be, also a debate. The academia must also be involved because they also have a role to play. Somebody has suggested that the courses being run at the law school must be taken there to the law faculties. That is maybe solving the problem. But the question also arises that the courses taught at the law faculties, they give the students the basic foundation of the law, theoretical. What is taught at the law school are professional courses. So most of the courses there are practical. Therefore, if the law faculties have the capacity to run those courses with the oversight responsibility of the General Legal Council, ensuring that, because here too we are talking about quality assurance must be applied. So the General Legal Council must also get involved in some of these matters and find a solution to the problem. Thank you.
Thank you, Chair. My second question. Judges are seen not to have a social life because of the kind of work you do, pressure on you to read cases and run around. How do you balance your social life with your career? Thank you.
Thank you. The life of a judge is something which unless you have come into a fold, you will, because the steps that you take, wherever you go, and the things that you do, you are in the public eye. So when we are also talking about trust in the system, you, the judge, you must behave yourself such that people will have confidence in the courts that they are coming for justice. It's not only that the justice must be served, but they must be seen that justice is being done. So, for example, if I'm a judge and I move my car and go around, taking on board all manner of people as my friends, it gives room for suspicion and the rest of it. So sometimes you have to isolate yourself. Me, for example, I pick and choose my friends. And if I haven't traveled out of town, Sunday, I will make sure that I go to church. So my work and church. I believe yesterday, the last nominee said something which we were all amazed that because of his work, his marriage has to suffer. That is a kind of reality. So, and the point is that even if you see a friend, a lawyer, you can't even go and shake hands with him because people will say that, he is a friend to the lawyer. So that is the situation we find ourselves. But you see, that is the job we have sworn to do. So we will manage it. Thank you.
Thank you, Mr. Chair. No further questions. Congratulations once again. All the best.
Thank you very much. Then I'll give the floor to Honorable Ayamba.
Thank you very much. Congratulations, my Lord.
Thank you.
Chairman, full disclosure, my Lord has been a very good friend of mine for many years. And I'm happy to see you go up as the Justice of the Supreme Court. Even if you are going to spend a year there, we know what you are going to send up there. And I wish you well.
Thank you.
My Lord, first time I appeared before you was about 14 years ago.
Oh, that's so.
I remember Republic versus Oseji, Antonia Couture say, Jambafo, also Professor Jambafo. And the former Attorney General was for Oseji. Brilliant submission of no case, which you upheld. A 90-page submission of no case, which you upheld. And Oseji got out of the woods. I've read recently some decisions of yours, the Amewu matter, the Atufosi matter, that I know you to be a very bold judge, regardless of who is before you.
Thank you.
And that is commendable.
Thank you for the observation.
That's very commendable. What gives you that weight and motivation? Because the kind of cases that I've read you handle and taking those bold decisions are very political in nature. The stakes were very high. I would have wished my colleague Bafo to have been around, since he said most of your cases are overturned on appeal at the Supreme Court. Some of these cases that you also overturned came from the High Court. So I would want to hear your views on some of them. The Amewu matter, the Oseji, Jambafo, Atufosi and Co. So those are matters that you've determined already, so you can give us an overview. Thank you.
Thank you, Chair. In the Amewu case, is it what? Amewu.
Amewu. John Peter Amewu.
John Peter Amewu. That case is still sub judice. What came before us was for an application, interlocutory, for an application for interlocutory injunction. So the case itself is pending for him. The appeal itself is pending for him. So it will be unethical for me to say something about it. Thank you. In the case of Oseji,
do you still remember the facts? Talk about some rice importation from India.
From India, I do to some extent, but it's, as you rightly said, it's a long time ago. So what I would say is that in that particular case, or generally, my position has always been that as soon as I hand over my judgment, I don't think about them again. Because if you are dissatisfied with it, you have the opportunity to go out. So it will be very difficult on my part to discuss it now. Unless, so please, let's.
My Lord, I'll step it down and ask you if you still have some good friends at the bar, because when you are at the financial court one, anytime a case is brought to you and the lawyers discuss, they say, you are going to Justice Bright Mensah's court. You know, it's real. Even if he's dismissing your application, you won't even put a smile on his face. He will just ask you to go out. My Lord, all I want to entreat you and beg of you is to keep being yourself.
Thank you.
Keep being a firm judge.
Thank you.
And I wish you the very best. Thank you.
But you see, Chairman, please, my court is a very friendly court. Very, very friendly. If sometimes, thank you for the comments.
Yes, I'll give the floor to Honorable Hajia Ayamba.
Thank you, Chairman. Congratulations, my brother.
Thank you.
So hard, riding through those ranks.
Thank you.
I think this is something that needs to be discussed with those up and coming. Some people think you must just get up and get to the topmost level, but here you are. Looking at where you came from and the issues that we have at hand, especially on the ground, when you go to our villages, for that matter, our districts, what is your suggestion about facts that we don't have, for lack of a better word, let me say, lawyers around, where maybe in Pusiga you have a case, you even need somebody, you may have to be calling Accra. We don't have the judges. Sometimes one judge is handling so many districts, or there may be only 2 judges in one region, and they continue shuttling, going up and down. What is your suggestion? What will you bring up to encourage whether those who are already trained professionals so that they will take up places that are deprived, or judges to accept postings to such places?
Thank you, Chair. I think the solution to the problem is that the conditions of service, particularly at the lower courts, must be attractive to lawyers to start from the lowest bench. Quite often, lawyers who want to join the bench will want to join it from the superior court. But when we talk about the work of the courts, it's those down there who normally do the work of the court. Indeed, when we are talking about access to justice and quality justice for that matter, start from down there. So therefore, to attract lawyers to start from the lower ebb of the ladder, then it means that the condition of service must be very, very attractive. I myself, when I started, I was also started with going to other courts. It was because there were no lawyers available to be engaged. Not that they are not available, but they didn't find our conditions of service attractive to come to start from the lower. So the solution to the problem is that the conditions of service of the judges, particularly at the lower bench, must be attractive for the lawyers to start from there. I believe that if the conditions of service are attractive, many lawyers will join the bench. Thank you.
Chairman, my second question. Cases take so long in courts, whether rural, urban, whatsoever. Some even eventually they die and the cases are not ended. They are not determined. Thank you for giving me the correct word. Are not determined. What is your suggestion to ensure that at least we make sure these cases are determined very fast so that we don't have so much at hand?
Thank you, Chair. There are so many factors that come into play when cases delay in court. I will not go into that because I'm being called upon to offer an advice or suggestion as to how they may be addressed. The first is that the judicial service must get their system digitalized, because now the modern trends are that if we were to digitalize our systems, cases filed will be filed electronically. When they are filed electronically, the belief that we have to effect service, we also do it, the proof of service, if it is served, we will issue proof of service and then it will be uploaded into the system. So we will not get a situation where a bailiff who has said a process will not prove service. Once proof of service is not on the docket, though the process has been served, the judge cannot go on the case, and that will mean that the case must suffer an adjournment. When we also talk about e-justice system, we are also talking about virtual courts. In other jurisdictions, even in Africa here, Tanzania and Kenya have invested so much in the judicial system, such that once the cases are filed electronically and the submission of cases are generated electronically, so the Chief Justice will not even have the power or has no control over who should sit on a particular case or the other. Which means that as soon as the processes are served and everything is in place, a judge who has traveled to his hometown, maybe I might have traveled to Amasima, and if a case is put before me, I will not have excuse to say that I'm not in Accra, so I can't do the case. It's virtual court, and sometimes you can also use Zoom to do those cases. If we were able to do that, I think it would be a leap forward, so that cases will be tried as expeditiously as possible. But if we feel that we must remain where we are, we won't get far. So that is the solution I would prefer to the problem on hand. Thank you.
Chairman, what I'm about to ask might not necessarily be in the Constitution, but this is Act. There is this statement I've read in it that states that a child can have sex at 16, but can only marry at age 18. It has been baffling me because why do you think that someone has the right to have sex at 16, cannot marry at 16, but should wait until 18 because we say it's a law? Now, sex comes with so many things because you carry responsibilities when you go to have sex, whether at 16 or at 100. You may become pregnant. You may, a whole lot of things. What should we do? Should we bridge the gap between the 16 and 18 and make it that at least 18 is more acceptable? That the right for anybody to have sex is at 18, and when there is anything, even if you get impregnated, you could marry the one that you are interested in, or we should reduce it to 16 so that we don't even have that gap.
Thank you. I think the interment of which puts the marriageable age to 18 was thinking that by 18 years the girl would be a mature person to be able to know her responsibilities so far as marriage is concerned. Now, why should a girl have sex at 16 and not be permitted to be married? There's more of a moral question, sort of. Because look, 16 years, what does a girl know? The girl does not know anything. But if she's 18, and the Constitution even makes, I describe an adult person as 18 years. So if you are 18, the presumption is that you have seen life a little to be able to be independent or take for yourself when you are married. But if you are 16 years and they are taking you for, I think it's quite. At 16, the girl must be in school. They should not go and follow 45-year-old man. Thank you.
Sorry, Chairman. The response I was asking, with that, your explanation, I'm quite satisfied. But I need to know whether we should then look at, we should amend it.
Amend it to
18 years for both sex and marriage, or it should remain as a
to amend it to
18 years. To 18 years.
Oh, then that the girl can have sex.
Have sex at 16.
Hey.
My Lord, I think if that is done, the defilement cases will be a lot.
I see. But the point is that when this girl's waiting to 18, that is the question we must also settle ourselves with. If he remains in chastity to 18, well and good. But you as a parent, you will be sleeping and your daughter will be somewhere else, which you have no idea about. How can you control her? So please, let the law remain what it is, at least for now. Thank you.
Thank you very much.
Thank you, Chairman. Thank you.
Yes, Alhaji Omar, you have the floor.
Thank you, Chairman. My Lord, Philip Wright, congratulations.
Thank you.
My question is bordering on judicial or policy litmus test.
Judicial
or policy litmus test.
I didn't hear you well.
Okay. What is your stand on gun ownership?
Gun ownership. Gun. In fact, I think our laws are said that if you want to own a gun, first and foremost, you need to register it. So if your gun is unregistered, then you have already violated the law. And I'm sure that this is to prevent people from, using the gun not intended for the purpose for which the gun was acquired. So my position is that if you want to own a gun, first you must be an adult, and then you must also register it as the law requires. Thank you.
Thank you. The second question is, what is your view on the doctrine of separation of powers?
Separation of powers, it's somebody who says a political doctrine where the three arms of government are given their specific rules to pray. And that's overlap. It's overlap in the sense that you can't say that because you are a judiciary, you will not have anything to do with the executive. And that the executive will also not have anything to do with the legislature. In fact, the core idea of separation of powers is to ensure that the three arm of the three arms of government, there will be checks and balances. So no one arm will be controlling the others. So, for example, as of members of this house to ensure that when the executive is going astray from what it is required or they are required to do, you have the power to say that no, this one you are going ultra vires your powers. The same with Parliament. If Parliament passes laws which are ultra vires their powers, the judiciary should be able to tell the lawmakers that, look, here it didn't go well. You should have done this or you should have done that. So it's about ensuring that there are checks of balances so that there will be cohesion. After all, that is what good governance is all about. Thank you.
I have a follow-up.
Please do.
Thank you. My Lord, in recent past, the last few years, you have some interference and overlapping where Parliament is making decision, is not yet concluded, and yet the judiciary jump on it to make decisions to stop it. Is that not usurping of or interference in the separation of powers?
Thank you, Chairman. The law, as I understand it, is that if what the Parliament sought to do has to do with interpretation of the Constitution, then the judiciary is seized with that jurisdiction to go into the matter. It's not as if the judiciary is becoming a schoolmaster. Of course, in any event, Parliament, you are masters of your own, what do we even say it? Masters of your own rules. So if the rules are fashioned in consonance with the law, and for that matter, the Constitution, I do not think the Supreme Court will jump onto your head and say that, don't do this, don't do that. So, I would say that case in question that we are talking about, if it bordered on constitutionality and interpretation of some provisions of the Constitution, then the Supreme Court has a right to intervene. Thank you.
I wish you well. Thank you so much.
Thank you. I will then proceed to give the floor to Honorable Jerry Shai.
Thank you very much, Honorable Chair. Honorable Chair, let me take this opportunity to welcome the Honorable nominee and Nana Doctor and all I have a parcel of land in that area, so by extension, I'm a sub-chief.
Is that part of assets that you have declared?
Mr. Chair, I was given the land last night. Thank you very much. Nana Justice, congratulations and you are welcome.
Thank you. Thank you.
Honorable nominee, you've been a registrar of the court, and I believe for a period before getting to the High Court and then the Court of Appeal. And therefore, you are versed with a lot of knowledge on judicial matters. Respectfully, would you recommend any judicial reforms to this committee?
Certainly. Thank you. I've already made mention of some reforms that we can put in place to ensure that cases that come before us are tried expeditiously. And I made a point of this e-justice system. I think the rules of court that we also work with needs looking at again. For example, the High Court rules, CI 47. Indeed, we had the previous one, which was promulgated in the 50s. It was only in 2004 that we changed it, and that has become our tool that we work with. Now, there are also inherent difficulties or problems with some rules of our engagement. For example, interlocutory appeals. I'm talking about interlocutory appeals, both in civil and in criminal. Interlocutory appeals, when a decision is made by a trial judge, as the case is suspended, most often the party that is satisfied will want to go on appeal. In that case, and if he applies for stay of proceedings, it's certified the hearing of the case. So I want to suggest that yes, they have the right to appeal, but there must time limits within which the appeal must be heard, so that it doesn't affect the hearing of the case adversely. Now, coming to the criminal aspect of it. Now, this has become fashionable that if you are doing the case as a judge, when you cough, a party will want to go up. When you sneeze, and sometimes they go even as far as to the Supreme Court. Meanwhile, then the case will say, finally. So I strongly advocate that the right of parties filing interlocutory appeals in criminal cases where the prosecution has not even ended its case must be stopped. And we can only do that through the amendment of the law, that is Act, talking specifically about Act 30. Now, another area which also needs reforms is our jury system. We inherited this system from our colonial masters, Britain, where they started this system. As I speak, India, some Commonwealth countries like India, Singapore, and South Africa, they have abolished the system. Why? Because it's not functional. Now, our experience in our jurisdiction has shown that that system has outlived its usefulness. So I would advocate that instead of the jury system, there must be assessors. Now, if you permit me, I will give one example. When I was in the High Court, I did assess, that was before my transfer to Sekene in 2015. I did a case where I had summed up the evidence to the jury, and as much as possible, I did it that everybody in the courtroom, or maybe those in the courtroom who understood what we were saying, anticipated that the jurors were going to, bring a verdict of guilty. They came out and said that the accused persons were not guilty. And you see, the law is also that they are the judges of fact. So their verdict is even binding on you, the judge. You may disagree, but you cannot open your mouth. You have to work with it. And there was a doctor who has been subpoenaed. I've come from Ankara Psychiatric Hospital to give evidence in the case. The doctor was in the court when I was delivering my seminar. The man was so disappointed that he said that if that is what the jurors here are doing, that I will never come back again. He didn't come. So the case will have to be, I left it because I was on transfer to Sekene. So we can give examples, but because of constraints of time, I will not do that. But I'm saying that in its place, we should establish what we call assessors. In assessors, the judges who will try the case will be 3, and there will be lawyers. I mean, there will be lawyers who have become judges. They will sit on the case. And we have it on our statute books when judges try treason and high treason offenses. It's assessors. We don't do it jury. Our jury system here is porous. Some of them have become professional jurors. So that is one area which I will advocate. Thank you.